Hey, boys and girls, ladies and gentlemen, I'm here to talk about contract law. Well, more specifically, duress and how it works and how it's determined. So, recently, Blizzard has decided that it wants to change the contract or the terms of service that you are signing against your will. You don't have a choice in accepting or not. If you don't accept, you forfeit all your rights to your stuff. So that means you are forced to accept in order to keep the stuff that you've paid good money for. I believe this is duress, but maybe I'm wrong, right? That's why I have this pulled up. So here we have it, right? Duress in contract law is focused on the concept of undue influence. This means that the use of false imprisonment, threats, force, psychological pressure, or coercion to influence someone to act in a way that is not in their best interest or act in a manner they do not wish to act. From that alone, anything anyone does to force you to accept the TOS is against contract law. And you can bring them to court about that. But let's continue. Don't let's keep this. So this is upcounsel.com. I'm not 100% certain on how uh legal they are, but they seem to be a law firm of some sort. And this isn't the only page I found on it. We'll go through multiple pages, but I just want to give you guys a quick rundown on this, right? I was eating whenever I found this. Apparently Blizzard did this very, very recently, as of like March 4th or something. Let me see if I can get a specific date and time. Anyway, I don't have one, but that's okay. Let's continue reading this. Overview of duress in contract law. Compelling someone to act in a manner against their better judgment or to do something that they don't want to do is against the law. In the eyes of the law, any agreement made by a person under duress is invalid. Full stop. Period. End of the discussion. Just, I want to put that there, right there, okay? They do specify further, but if you are in any agreement you make is not something you want to do, but you have to do in order to, say, accept your games, change your credit card, whatever, that contract is no longer valid. If you are forced to do so, to do any of this stuff, no longer valid. Full stop. End of story. It's against the law, okay? You can take this to court, criminal court, if I remember right. Just, take that with a grain of salt, contact a lawyer, but definitely, when duress is determined, it is not based on the pressure exerted on the person, but their state of mind. In the contract law, in a contract law court proceeding, in order for duress to exist, there must be a legal or wrongful act. When a claim of duress is filed, it is because a party wants to prove that their agreement to a contract wasn't made in good faith, making the essential requirements necessary to form a contract unfulfilled. If a party is claiming duress because another party is threatening to file suit for more money, that would be an invalid reason because filing suit is a legal action. A party fearing for their safety can file duress. An example would be threatening to harm someone's family if they refuse to sign a contract. If a wrongful or illegal threatened act takes place, that qualifies as duress. Theft is illegal, guys. If Blizzard wants to take your money after giving you a product and then take your product away that they gave you because you purchased the product, that's theft. Full stop. Take them to court. Let's see. Duress and consideration. Consideration is what is referred to when bargaining and exchanging takes place regarding goods and services. It is vital, and without it, a contract does not exist. When one party benefits but the other only receives what is initially promised, this is duress. Checking if consideration was given and is a quick way to determine if there is a claim for duress. When a promise is made, the promiser is legally bound. This does not constitute consideration. If both parties benefit, then consideration has been established and there is no claim for duress. There are three consideration types: executory, executed, and past consideration. In contract law, consideration need only be sufficient versus adequate. In this context, adequate is the value of the consideration in terms of the economic value of the transaction. This does not mean, however, that the validity of the consideration is affected. Legally, the only requirement is that the consideration has a minimum economic value. For those of you who don't know, this means that if there is a transaction and they go back on that transaction, yeah. I don't know if I need to go into more detail about that. It means that if there's a transaction with something that costs money and you sign a contract for it and then that item is taken away because they changed the terms of contract, that is right here. Right here. They can't do that. Full stop. This is hard law, right? Contracts entered under duress. Duress to an individual. When an individual enters into a contract because of threats to that person physically, then the contract may be set aside as long as the threat to physical violence was the reason the person entered the contract. In this case, there is no need to establish that the party would not have entered into the contract had there been no physical threat. Duress to goods. Claiming duress due to goods is not recognized as a valid reason to set a contract aside. Economic duress. Economic duress is a common claim in dispute of commercial contracts. Proving duress in a contract requires three things to be provided. There must be an existing continuous contract between the defendant and the plaintiff. The defendant has threatened to end the pre-existing contract. The plaintiff, under duress, accepts and enters into the contract because of that threat. Blizzard, we're looking at you. Courts also look at other factors when determining if one party is exerting undue pressure on the other party. These factors include the time frame in place for each party regarding the completion of contract performance, the level of bargaining power each party had when the agreement was made, the mental state of each party at the time the agreement was made, determining if each party felt the agreement was fair when it was made, if any contract note modifications were in place when the contract was agreed to, whether the other legal remedies provide reasonable solutions to the situation. Related legal terms. Civil lawsuit. When one person claims they've suffered a loss due to another person's actions. Mutual assent. A contract between two agreement parties. The preponderance of evidence. When evidence by one party is more convincing than that of the other party. If you need help with duress contract law, you can post your legal need up on UpCounsel's marketplace. UpCounsel accepts only the top 5% of lawyers to its site. I don't care about that. So I hope that helps you. And I hope everyone understands what I have just given you. I don't think that's the only one, right? That's not the only place that tells you this, but it's very important that you remember this, because this applies to anything you sign, anything you agree to is a contract, as long as there is a monetary exchange, as far as the law is concerned. And if you agree to terms of service for purchasing an item, and then those terms of service are changed to take away your item if you don't agree to those terms of service, that's duress. That's how that works. But of course, I am not a legal expert. I do not have any experience or connection to legal law. Please, by all means, contact your lawyers or whatever you want to do to fight this properly. Give Blizzard a fucking black eye. Fuck this. This is stupid. To be clear, what has happened with Blizzard is Blizzard has changed their recent terms of service where you have to accept them in order to continue playing their games, to change your credit card, to disconnect to access anything in your account. They are forcing you to accept. That is against the law. Full stop. And reminder, Blizzard's an American company. I'm pretty sure. Actually, let me double check. It might not be an American company. If it's not an American company, then that changes a lot of stuff. Let's check. Blizzard Entertainment, their website, scroll to the bottom. We want to look at the about. No. Let's see if we click contact us. No, Legal. No. Privacy? No. It's not privacy. So let's just do a different thing. Santa Monica, California is Activision Blizzard headquarters. It's an American company. In California, that may change some things, but not a lot. Contract law is pretty universal in most places. So, you know, have fun with that, guys. I hope this helps you, and I know this makes me feel better. I haven't accessed Blizzard stuff, so I haven't agreed to the new terms of service yet. And I don't plan on doing so until they fix this and they can suck my dick. Otherwise, I hope you guys have a nice day. Bye.